Hey, I'm Dick Ortega from Ortega Group, and today we have with us Sean Rice. We're going to be covering everything from trust and estate planning, some common mistakes that our clients make, and how to protect your assets and plan for the day that you're not here. Everyone should be tuning into this. I think it's very valuable information and helps you put your mindset in the right place to how to protect your business, your family, and your assets. All right, man, thanks for doing this. I've been working for a while on doing trust and estate planning, but haven't really gotten around to asking you, how did you get into this? How did you end up leaning into trust and estate planning?
Yeah, I was always involved in real estate initially and general civil work, but a combination of family and friends who needed estate planning work, and I always did some probate work in my office, and some of the attorneys who I worked with and who were partners with me for a while also did probate and estate planning work. And so we got pulled into that area of law. And then additionally, most people hold their assets in real estate in some form or another when they pass, whether it's their homestead or some investment properties. So tying all that together, I started helping plan for stuff for a couple friends and family, including my own family. They were involved in real estate and investment stuff. And you begin to realize quickly that as a lawyer, that the way that people typically hold things isn't the way to hold things, and that you need to be a little bit more cautious, and that you're exposing yourself to a lot of risk unnecessarily if you don't plan properly.
Right. Yeah, it seems like there's two aspects. There's the asset protection, liability protection, which is incredibly important, but then even after you're around, making sure that it passes smoothly to your family and avoids taxes and things like that. And so I want to get into that in a little bit, but I was looking you up and I realized that, man, you graduated right before the financial crisis in 2008, like a couple years or a year before. And I have my own perspective. I was working at the bank and I was doing financial planning at that time. But as a lawyer, do you think that influenced you and seeing people lose assets? And what was that like from the lawyer side and you getting involved, starting your career and seeing that unfold?
It was a mess. I remember the whole legal game. You know this better than me because you're in court more frequently than I am. But the way things have changed since COVID, even where everything's now Zoom hearings and stuff like that didn't exist in 2008. Everything was still in person, and most motion calendars, for the lay people who don't understand what that means, is between the time your case starts to the time you go to trial, there's a whole bunch of stuff that needs to be fought and litigated. And you go to a motion calendar to fight over some little discovery issue. I asked you for X, Y, and Z, and you only gave me X, and we fight over whether or not I'm entitled to Y and Z. Motion calendars used to be 5 to 10 attorneys waiting their turn patiently, and the judge gave you a lot of time and leeway to talk and discuss your case. But once the foreclosures hit and they started filling up judges' calendars, those numbers went from 5 to 10 people showing up to a line being outside the judges' chambers, and there was 50 people waiting to be heard. And it was a huge mess. Many judges just left the bench and were like, I'm out. I didn't sign up for this.
Yeah.
The amount of foreclosures prior to 2008 that it took place roughly annually in Miami-Dade County was somewhere between 7 to 10,000 per year. And between 2008 to 2012, the average number was somewhere between 50 to 80,000 foreclosures per year.
Per year?
Per year. So judges' motion calendars and chambers just became a zoo, and it became a disaster. And it was...
and in this turmoil, I mean, there's... being a litigator now, I see the pressure that judges are under to manage these massive dockets that they get blessed with, and but I can only imagine how much pressure that was, and the fact that everybody's kind of being bunched in together. I'm sure that there was investors that had assets. I'm sure that there was single family homes and people that were losing their homestead, and they were all just being like cattle pushed through, right?
Yeah, the vast majority were single-family residential stuff, right? Because that's what most people are going out and purchasing. But there was some commercial stuff mixed in there as well. And then you had, the sharks who started to come in afterwards too, and who bought cheap debt from the banks who were trying to offload it, you know what I mean, from a corporate standpoint. So you had these more savvy third-party investors who were coming in, and they were a little bit more nimble and aggressive than the big, institutions like Bank of America or Countrywide or any of these other guys, Wells. But it was definitely interesting, and it wasn't just Miami-Dade. I remember going to a Naples court hearing, and the line was out of the courthouse itself.
Wow.
And there was over 500 cases on docket that day, and of the defendant homeowners, there was maybe 4 or 5 defense attorneys, including myself, and the judge, was not didn't want to hear defense counsel's arguments.
Yeah.
He wanted to move cases along and process them, which is understandable. It's a huge administrative burden, and it was an eye-opening experience. I felt kind of like a public defender for civil residential real estate cases, essentially, is what it was, because there were so many cases. All of a sudden, you go from, I was doing closings and transactional work and probate work, which is very calm and measured and well-established practice, to a complete zoo.
Yeah.
Literally.
And that's part of what we do now is and you kind of just brushed up on it, is these people that started buying in, they had more money, they were more aggressive, they had more strategy, and presumably they also had better corporate structures to be able to acquire these properties.
Yeah. They had their own little LLCs, or even real estate investment trusts. Some were more savvy than others, but you know who they were, and you get to see these same people on repeat every day, because I was in court 4 times a week, you know what I mean, in front of the same judges, in front of seeing the same plaintiff's counsel. You knew who was representing Wells or Bank of America, and you knew who was some smaller hired gun for these smaller investment firms who were trying to scoop up properties and turn them into new investments for themselves.
So fast forward to what we're doing now, and it's a pain point that I see with my clients, right? The people that either came from private equity or funding or have the knowledge, they're playing offense and defense, right? They're acquiring properties, and they're making sure that their different portfolios are protected, segregated, but I also have a lot of my clients that they've just been working hard for 10, 20, 30, 40 years, and they just started, again, working hard, sometimes in blue collar, oftentimes in construction. We do a lot of construction. We represent a lot of clients and companies in construction. And now they're 10, 20 years out, and they've been able to acquire some real estate assets. Their business is doing well, and they've never circled back to putting that protection in place. So tell me a little bit about what you think. Who do you think benefits the most from proceeding to creating an actual trust or estate plan, and having a vision as to what happens to their assets while they're around with us and in the event that they pass?
A couple of things that you mentioned there that's what I encountered a lot too, especially in Miami. You got a lot of I'm part Cuban, so you got a lot of people who came back in the 60s, and it was just start to hustle and survive, and then it became thriving after some time, starting a construction company or a mom and pop business that blossomed, and then it allowed them to acquire a couple extra investment properties, a duplex here, another single family over there, to start acquiring a little bit of assets. And the next thing you know, 20, 30 years later, you have an estate which is got some value to it, right? You've got your homestead, you've got your business, and you've got 2 or 3 investment properties, which now in Miami, any little piece of property costs $500,000, probably more if you bought it back in the day, and you've got it in Southwest Miami, anywhere, So all of a sudden, you've got a nice little nest egg, and you've figured out, I need to protect this nest egg. And when I was younger, it was just hustle, grow, thrive. And then eventually it became, all right, now I need to sit back and evaluate what I've created and how to protect it and make sure how it gets passed to my kids. So anyone who fits that category should consider things like creating, if you own things in your own personal name, that's a problem. You're exposing yourself to risk. And a lot of you know what you know. These people were just, they had limited tools, and they came in and they knew one thing and one thing only, and that was work hard and figure it out and get by. And then after some time, now they're no longer getting by, they're thriving.
Yeah.
And they've acquired assets. And those people, typically, including my own family, when I had to sit down and talk to them, I was like, hey, we need to do stuff to protect and plan and make sure that this stuff survives. They start to understand the importance of it, and they lay it out for them, and they start to take advantage of these laws, which are designed to preserve and protect them. And then the other flip side would be, I guess, younger businessmen who are built in the same mold, you know what I mean? Who are here hustling, making a name for themselves, create a little construction company that then turns into a significant asset, and then they leverage that asset and the profits from that asset to then turn around. Again, real estate is the common denominator for me. That's my background in history. They start to realize, hey, I can acquire a couple other assets, and they make it a separate business. And those people also are ripe for needing to assess what their estate is worth and how much risk they want to be exposed to and how to protect it.
Yeah. Well, actually, you just reminded me of something I was going to mention earlier. So while you were standing in line in courts for foreclosure cases, I wasn't even going to law school. I wasn't even thinking of law school. I was working at the bank, and I'd done some financial planning before. I did mortgages, did some securities. I had a securities license, but more and more as the financial crisis went into like full steam, I saw businesses that they were emptying out their bank accounts, they're maxing out their lines of credit. It was pretty rough, and then I even had to deal with. That was the first time like my exposure to anything in the legal world was people coming in and they had leaned their account and they had completely cleaned it out, and the client didn't understand. Well, I had money in here, and they were mad at us. I was like, this happens way above my pay grade, buddy.
When you say lean their account, explain what you mean by that. Give me
I don't remember the specifics, but it's knowing now what I know as a lawyer, it must have been that they went either a bank, which happened often, or foreclosure, got a deficiency judgment on the mortgage, or the house didn't cover because it was underwater.
I see.
Or other judgments, because a lot of businesses also had other types of loans, and so they probably went through the full foreclosure process. I suspect, couldn't even afford a lawyer. They might have just been a default judgment, and they figured out where their assets were, and they just went to the bank and leaned their accounts, and the bank has to follow the law, the court order, and send that money across. So the client comes in, they're trying to take care of their family, pay their own personal mortgage, and the money is
gone,
or frozen or completely gone. And there was a lot of people just trying to survive, right? Like taking money out of one account, transferring it to a different bank, and then that opens up a whole can of worms with like fraudulent transfers and things of that. But this wasn't about staying wealthy or cheating people. It was I saw it in these clients' customers' eyes at the time. They were just trying to survive and feed their family.
Yeah. No, the term that was used in the industry was strategic default. Strategic default. If you're a homeowner and everybody thought the market was going to keep going up, it was boom time. And as is typical, the market fell off after 2007, 2008. And now this asset that you thought was going to go up indefinitely is worth half of what it was.
Yeah.
And all of a sudden your adjustable rate, interest rate has gone up, and your monthly payment is, so you had people scrambling to figure out a way to stave off the bank and get involved in the court process to give them more time and maybe recuperate some rental income or stuff and survive, and that's the strategic default angle.
Yeah.
Right?
So let's talk a little bit about what we're doing now to help clients either protect their assets or plan for their estate. And part of the reason we started working together is because I was getting inquiries and requests for this stuff, and I was very familiar, given my background, with corporate structuring. Making sure the LLCs are properly formed, have the proper governance documents, having liability protection and segregating stuff. But once it came into trust and estate planning, that was outside my wheelhouse. And so let's talk a little bit about, tell us a little bit about what are some of the primary benefits that can be accomplished through these tools. Whether it's creating the trust at the top structure and then having the proper structure for each asset that you have, whether it be multiple businesses or properties.
The main benefits are twofold, right? Which you kind of briefly touched upon, which is number one, you want to ensure that everything that you worked for all your life is preserved and passes to whom you want it to pass to, your heirs, presumably. And then the second is to protect and insulate yourself from liability in the event that something happens, Both of them are very important and they serve different things, but they tie in together and they're and the more that you practice, you see this, law is inextricably intertwined one in another. So real estate law all of a sudden touches into probate and trust and estates law, and trust and estates law and real estate law inevitably touches into tort law, and it's unavoidable. So the idea is, if you structure your assets and your estate appropriately, you're going to essentially segregate your exposure and your risk and your liability. So that's one of the main steps. The first step, I would argue, if you're a business owner and or a property owner who uses your properties for investment purposes. Each property should be its own self-contained business, and it should be formed probably as an LLC or some business entity of some type. And if you operate it correctly and you keep the books on it appropriately and you run it like it's supposed to be run, like its own distinct business, then theoretically you are protected and insulated from liability, from something that you would do outside on your own. Let's say you have a unavoidable injury, you run into somebody while you're driving personally, right? You get exposed to risk and liability that way, and then all of a sudden you are liable for a $100,000 injury to someone, or you're walking your dog and your dog bites somebody. Anything, can expose you to liability. If you own all your assets in your own personal name, all those assets are up for risk. Anyone who is going after you for any injury that you have done to them, however innocent it may be, is going to go after all of your assets which you own personally. If you own them within its own business structure, then they are not your personal asset. They are a business which you have an interest in, but it is segregated from any personal actions that you have done. So that's step one towards minimizing your risk, preserving your assets, and making sure that you don't get yourself into more trouble by owning everything personally. The end game, or the goal, is you don't want to own assets directly, you want to control assets. That's the key. And it took me a while to understand that and learn that myself. And then once I saw how the significance of that and how applicable it was, it became very obvious. And you see how infrequently people are operating that way. The vast majority of people are like, no, this is mine, I want to own it.
Yeah.
And that old school mentality is not the smartest way to operate your business and your estate plan. Conversely, anything that happens within that business, someone slips and falls, or again, a dog bite occurs on that property that you are an investor in and that you get rental income from. If you're operating it correctly and you keep your bank accounts and you're not commingling assets and you're not doing all these things that you shouldn't be doing and treating it as if it's your personal asset, and instead treating it as if it's its own distinct business entity, then whatever injury occurred there or whatever damage occurred there is limited to whatever happened in that business, and they can't come after you personally. So that's known as inside liability versus outside liability, and you're protected from both. It kind of insulates you from both. And that's one of the first steps that is taken. The second step, which then ties into estate planning, is how do you now incorporate these businesses that you've created in this classic scenario that we talked about before. You had some classic Miami case, old Cuban guy who came to Miami in the 60s and had to run and hustle and make a life for himself, a new life for himself. And now he's created a a business which he's used to purchase 3 or 4 other properties, which gives him supplemental income. And now he's got a business that is worth something and 3 or 4 properties that are worth something, and before he knows it, and a 401k or whatever, you know what I mean? Any number of assets together, and now all of a sudden he's got a $5 million estate picture, right? And he owns it all personally in his name, and he doesn't even have a will. How is that all going to get passed, right? So that person should create separate business entities for each of these structures, and all of that should tie into an overriding trust document. There's a lot of different trust documents, a lot of different ways to set it up, but generally speaking, the vast majority of people are probably going to want a revocable trust during their lifetime, which then may or may not turn into an irrevocable trust for their children moving forward. But the advantages of a trust are, number one, like we said, you direct how your assets and your estate passes to your heirs, to whom and how and under what kind of rules. You can limit certain things. A trust, at the end of the day, is a private contract between yourself and your heirs, your beneficiaries. And it's a fictional legal entity that has quite a bit of power, and its primary power is making sure that your assets go to whom you want.
Control.
Yeah. And the second beneficial thing is you avoid the probate and court process. It's a private document which automatically dictates how your property and your assets and your estate passes, and it controls. And you're going to avoid a lot of headaches and having to go to the judge to ask for it.
You're going to avoid your children and your
right,
heirs.
Yeah, you're going to avoid your estates a lot of headaches by setting it up this way, and streamlining the process and keeping it private too.
Yeah.
Other
actually,
thing,
you just said private, which is something that we haven't discussed. But you know, as a litigant now, I represent companies in a lot of commercial disputes. But I did, for a period of in my career, I worked at a firm where we did a lot of personal injury, and one of the first things you look at is are there deep pockets, right?
Yeah.
Like if you have a defendant, and you might have a great case, but if the other person is bankrupt or is a company that has dissolved, you may not have much to go after, and then juice is not worth the squeeze. Unfortunately, somebody's been wrong, somebody's been hurt, and one of the initial steps that a personal injury firm does is analyze what are the recovery options. So there might be insurance, there might be assets that you can lien after you get the judgment. So you first have to prove your case. But if you're doing it right, you're already anticipating, well, once I win my case and I get my judgment, how am I going to collect on it? Because nobody just wants a paper judgment or for a big number that they can hang up on their wall. They actually want to recover that money to help their client, recover from their injuries.
I'm curious, I've never asked you this, but how would you guys go about that? Do you guys do like skip trace? Did you have services that would look into all that stuff to try and ascertain what the asset picture of the potential defendant was?
Yes.
Yeah.
I mean,
that makes sense.
In a lot of the cases we handled, we were litigating against fairly large defendants, right? Tobacco
corporate
companies,
stuff,
asbestos companies, or pharmaceutical companies that were large, and then we had to play a lot of their games, right? Because they will file for bankruptcy. They had the Texas two-step. There's been a lot of we were involved in the opioid litigation. We had several mass torts going on, and also tobacco. But generally speaking, that initial identification of whether there are even assets is not the problem. There's going to be a lot of problems because those defendants know how to defend themselves, and they have phenomenal counsel. But you know that there's going to be assets there, so you just focus on your case. But then there's the other side, like there was this Airbnb case where somebody went, they were injured by carbon monoxide and poisoning, and it was in a foreign country.
Oof.
But and I wasn't working on that case, but some of our lawyers were, and one of the initial investigative steps was like, well, who owns this property? It just turned out that, well, you have Airbnb, so there's potential defendant there. There's going to be assets, but you sign a very strict contract with them. There's arbitration. There's a lot of hoops to jump through. But then there's the property owner, and Airbnb is saying, well, we don't own the property. We're not liable for it. So the property owner was actually based out of the United States. So there was a lawsuit brought against those people to try to recover for the death of this very unfortunate death. So yes, there's definitely a lot of initial research, and depending on the jurisdiction, in Florida, which is one of the things I want to get back to, privacy and anonymity. In Florida, we have a lot of good public records. It's pretty good to find out who owns what,
Right.
Which makes it difficult if you've acquired stuff and you're trying to protect it. And that's why another reason that these structures are important. But yes, we actually did skip trace. We identified the potential defendants. We looked at their bankruptcies. Sometimes we can track down properties that they own.
Right.
So all forms of public records, whether it's courts, property record searches, state secretary departments, to figure out what is owned and how are we going to be able to recover for our client, the wrong that they've suffered. Then. What was the other thing that we were just talking about?
No, but we're on the same page here, still talking about how do you figure out who owns what sort of stuff and those preliminary steps.
Yeah.
If
Well,
you're a plaintiff's attorney looking to go after someone who has committed some sort of injury or damage or whatever.
Right. So then I want to circle back to privacy, which you've mentioned a couple times, and privacy is not legal protection per se, but if the person that has a claim against you or their lawyer can identify that where your assets are, what you have, they might just move on. Or you might make it incredibly difficult for them. As opposed to, if they're able to go on Miami-Dade property record search or, Hillsborough or whatever it may be and quickly identify that you own 10 properties, 15 properties, and it's not too difficult to figure out if the mortgages has been paid off. So in a couple of hours, my team can figure out, you have 10 properties, 5 of them are paid off, and each one has, X amount of dollars in equity. So you just put a big target on your back, and I'm going to focus in, and I'm going to, make sure that I can make my client whole for the wrong that you did to them.
Yeah.
But on the other side of that, if you're difficult to find, it really slows down that process and makes it more difficult for potential claimants and attorneys to come. So the point there being is, from the outset, anonymity and privacy may prevent the lawsuit.
It's the first hurdle.
It's the first hurdle. And then the structure, assuming they find this stuff or they come after you anyway, then you get to the next hurdle, which is like, what does your structure look like?
Yep.
And does it actually protect you?
Right. Exactly. So that gets into a little bit more complex planning, but the privacy aspect of things is not very good in Florida comparatively. And quite frankly, most of the jurisdictions are that way when it comes to corporate records and property records. Every county should keep them. Everybody, for the most part, knows who the owner is. But if you look up the owner of a property where an injury is sustained, and it says, Sean is the owner, then it's like, okay, I know that Sean is the owner, and that step one is done, right?
Yeah.
If it says Sean is not the owner, but South Miami Address LLC is the owner of this property, okay, so it's not owned personally, but it's owned by an entity. Okay, let me go on to the Department of State Division of Corporations and see who owns this corporation. Then you look it up and you see, which is sunbiz.org for the people who don't know. It's a public record of who owns what companies. And in that one, it might say Sean is the owner of the company. Okay, so Sean owns the LLC, which owns that property. All right, so now I've kind of put it together. I might not be able to collect, or I might be limited to collect to this LLC, so that already indicates to any plaintiff's attorney that this is a little bit more sophisticated of a property owner who has the appropriate structure in place, which is going to segregate his liability potentially. Right. However, if the owner of that LLC doesn't show Sean's name anywhere, and it points to another jurisdiction which has more privacy conscious laws like Delaware or Nevada or Wyoming, or even a couple others that I'm starting to figure out exist as well. But the minority of jurisdictions, the most prominent of which are Delaware, which most people know, that's why all the corporations form over there, all the big major corporations at least, Nevada, Wyoming, they have privacy rules written into their statutes which don't require a disclosure of who all the owners are. So if you have created an entity like a parent company to hold your domestic Florida-based LLCs, then it provides that additional layer of privacy and anonymity, and it provides an additional hurdle that anyone, especially in the case of a plaintiff's attorney, to figure out who is the right person to sue here and what property or assets does Sean or Dick or whomever hold here, right? So that's an important part of the puzzle as well. And that sort of, it's like Legos almost, you know what I mean? This kind of planning, and it's a puzzle that you have to put into place, which insulates you from liability, creates more anonymity and privacy, and then overall you tie that up into the bigger parent structure, which is your estate planning trust structure.
Let's talk a little bit about taxes. There's like some basic, the tax code gets complicated, and I'm always asking questions. I have a couple of accountants and lawyers that primarily deal with tax matters, and I'm always blowing them up to help me clarify things. But there's definitely a few relevant tax benefits of creating these structures. You know, for example, I've had clients come to me, they're earlier on in their life, and they say, well, I don't want to wait till I pass away, I want to give this property to my son. And that could potentially lead to them losing out on the step-up basis. So explain that a little bit to us, why you want to own these things and not pass them on too early.
But there's different ways to do that. You know, some people do it through a simple mechanism like a ladybird deed or something like that, which transfers the property. It creates a remainder interest in whoever you want your beneficiary to be, and then they get the stepped-up basis at the time of your passing. But a similar sort of thing can exist with the creation of LLCs or even the creation of a trust. But the primary benefit, there's various ways to do this stuff, and it gets complex fast. But if you create the primary tax benefit of creating a trust is going to be, especially for people who have big estates, or the primary concern is going to be the estate tax problem. Now, right now, the estate tax problem is high. It's like 15 million per person. But if you have significant assets and you're a wealthy individual and you are above that amount, let's say your assets are $20 million, so you're $5 million over the estate tax exemption amount, then every dollar that is over that estate tax exemption amount is going to be taxed at like 40%. So what happens is, in that scenario that we just put together, you pass $15 million worth of your estate passes tax-free to your heirs. However, $5 million, which is not an insignificant chunk of change, is taxed at 40%.
That's $2 million.
What's 40% of $5 million? $2 million. All of a sudden, your heirs have a $2 million tax bill to the IRS. What ends up happening usually, especially in the case of people who have real estate, your heirs, who are typically younger, typically less experienced, are scared of this huge tax bill. They end up selling properties that you worked all your life to acquire and provide for them in order to satisfy this tax bill. So one of the mechanisms for doing that is creating a trust which kind of divides your estate in two. The name of the trust, there's a couple different types of trusts. It used to be called an AB trust. Sometimes they'll call it a marital trust. But the appropriate term nowadays is a QTIP trust, which translates to Qualified Terminable Interest Property Trust. It's a tax designation, an IRS thing. And essentially what it does is it separates your estate in two. One for you, one for your spouse. That's another thing I was going to say. This only can exist for people who are in a traditional marriage structure, and this is what they want to do in order to maximize their estate tax exemption amount. And so your trust gets divided in two. One is yours, one is your spouse's. And when you pass, you are able to use the full $15 million of the exemption that is allowed under the law. And then when your spouse passes, they are allowed to use the $15 million exemption. So you effectively double your exemption amount from $15 to $30 million. Why is that significant? Because in the traditional scenario, if you pass without any, what is called intestate, without any will or trust, or even if you pass with a will or a trust that doesn't incorporate this structure, you use the spousal exemption, which is whatever spouse survives the spouse who predeceases, they get all that property for free. And you think, oh, great, I didn't have to pay any taxes. I got a huge blessing here. So I inherited, as the surviving spouse, $20 million. Everything is great. But no, because then when you pass, all of a sudden that tax bill becomes due from to your children or to your heirs, whoever you choose them to be. And that's a significant problem, which we have already kind of spelled out here. Essentially, the spousal exemption, which sounds good in theory, prevents you from each using the estate tax exemption amount as it should be used to thereby maximize your estate tax exemption amount.
Yeah.
And if you're able to both use it by using something like a Q-tip trust, then you effectively double your amount and your $20 million estate passes tax-free, whereas before you would have had a huge tax bill. So that's step one. Also, in that scenario, speaking of your stepped-up basis, when your children inherit, they inherit at a stepped-up basis for those properties that are involved.
What's the stepped-up basis? What does that mean, like in lay terms? 'Cause we had one recently where by the time the client came to us, their mother had already transferred a property to them, and I was like, okay, great. Now we got to figure out how to unwind this.
Essentially, what it means is when you inherit.
And the mother was still alive.
Yeah. When you inherit, what it means is that you get, for taxation purposes, the amount of the property value is stepped up to what your current market rate is, right? So in that scenario, for example, your parents, again, going back to this traditional Miami sort of scenario, you have a Cuban family that comes in here and works and hustles, but purchased a property back in 1970, which cost them $50,000 to $100,000 back then in Miami. But subsequently, they've worked hard and they've acquired assets, and that $50,000 to $100,000 house is now worth $500,000 to $700,000, and it's a significant appreciation in value for the underlying asset, which is the house. If you do it this way, when you acquire it as the heir, you get this stepped up in basis, so that way it's now valued as if it was $500,000 to $700,000. In the opposite scenario, it goes all the way back to the original purchase price, which was done by the parents or the decedents, and then you have another big tax bill when you turn around to try and sell that property, because now you have capital gains tax of $500,000 plus K, whereas if you get the stepped up basis, let's say you grab it after via the trust, and then you hold on to it for a year or two, and you turn around and sell it, and the stepped up basis price was $600,000, and you turned around and sold it for $650,000. So you only have to pay capital gains on the $50,000. Right. Whereas in the other scenario, you're going to have to pay $50,000 to $100,000 is the original purchase price. Now you sold it for $650,000, and whatever that difference is, you're going to pay capital gains on that.
The full amount.
And it's a significant tax burden as well.
Yeah, that's something that,
most people don't think about, right? And they're just busy living their life, struggling to make money. And
not to criticize my people too much, but I understand, and I see it myself too, particularly with, whether it's Cubans or Hispanics generally that, have come here and have just worked up their whole life just building something. They don't have the right structure, and it's just not normal in their culture to like really make these plans. And I was experiencing that even way back when I was working in financial planning. Like Cubans in particular, they don't even want to hear about life insurance. That's just a concept that I'm not paying life insurance, but my wife will figure it out. But it's more typical in some of my, American-born or just younger people to be thinking ahead, right? And I don't, again, it's not a critique that these people are bad in any way. They don't have the information, and they don't know that a little bit of planning can go a long way to protect what they've built, because these guys have been working really hard. And then whether it's a potential liability for something that they did or something that happened on one of their businesses or properties, or just Uncle Sam coming in and taking a huge tax bill.
Yeah, like you said, it's that mentality. It's ingrained into that generation. God bless them. You know what I
Yeah,
mean? But
yeah.
it's like a trabajar. You know, we
Yeah,
gotta
yeah,
go. We gotta go.
yeah.
I came here with nothing, and the only thing I need to do is start working hard, and I'll figure it out.
Yeah.
And now it's time to figure it out.
Yeah.
You know what I mean?
So, you and I have been discussing briefly about single member LLCs and the impact that that has. So let's talk a little bit about let's distinguish between at a basic level difference between single member and multi-member, and then the big impact that it could potentially have from a liability standpoint.
Well, it is what it sounds like, right? If you create an LLC and you are the sole member, it's a single member LLC. If you create an LLC and you have two or more partners or members, as is the official legal term, or even if the other member is a spouse or a family member, you start your business together and you guys are both listed on there as the multiple members of that business, then you are a multi-member LLC. It is that simple as it sounds. The distinction is important because in Florida, more creditor protections are provided, or rather debtor protections are provided to multi-member LLCs. I should say protections against creditors and stuff like that for multi-member LLCs versus single-member LLCs. And to not get too deep into like the legal weeds here, the reasoning of the courts has been, hey, listen, if you're just Sean and you're going to do something shady, or you're going to run a fly-by-night operation and you just throw an LLC over your head, you're not going to get away with stuff. That's what it comes down to, right? And we're not going to provide you the same amount of protection that we would to if Sean and Dick legitimately opened an LLC and started transacting business and doing stuff, but then made a mistake and have a debt. And so in the event of the latter, if it's me and you opening up, or whomever, two people opening up a multiple member LLC, and you're operating and you're conducting business, then the amount of remedies available to third parties is limited by Florida statute. And it's limited primarily to something called a charging order, which is essentially just a money judgment amount. So if me and you are create a multi-member LLC, and we call it, Perfect Law LLC, and something happens and somebody gets injured, or we have a debt that we need to pay and someone comes after us, then the only remedy that they have access to is that charging order money judgment amount, whatever that is. Whereas in the case of the single member LLC, there are stronger protections afforded to the creditors rather than the single member LLC, and the creditor could theoretically even come in and take over the business and start running it and managing it as if they were the owner. So the law allows for judgment holders, people who have a judgment against your single member LLC, stronger remedies in order to satisfy that judgment. They can come after you, they can take over your business, they can sell assets from your business, they can start running your business in order to satisfy. Whereas in the case of a multi-member, it's just, hey, you are entitled to X amount of dollars, and this is what can be done. The only thing that can be done is they can direct distributions be paid to them to satisfy the money judgment amount.
How long have we been going?
45 minutes.
All right, I'm done with questions. So you tell me what else you want to talk about. Something we haven't. He can cut this stuff out, but I guess what other areas haven't we discussed that we had planned to kind of, or that we normally see? We should talk about some specific examples of like some clients.
One thing that's important that we haven't talked about that I think is important, especially for the clients that you are mostly representing, is that big part of your client base is construction businesses and people who are
subcontractors and owners of construction
Right.
companies, etc.
a lot of these people, obviously, that is necessarily tied into real estate as well. How do these people want to protect themselves, and what pitfalls do you need to worry about? And one of them, which we've discussed multiple times actually, but is a lot of these people are engaged in both, well, whatever, let's just say they have their parent company, which is a construction company. They are a GC, right, a general contractor. And that money makes business, so they invest in properties for long-term hold and investment, right? They purchase a duplex or a fourplex or something like that, and that should be its own separate business, which is isolated from this parent, or not, you shouldn't even call it parent, this original business, which is going to be the main breadwinner initially. But also these types of people, because who run these types of construction businesses, because they have the know-how, they will often identify properties which they can get perhaps on the cheap, fix it up, turn around and flip it, make some money on it, right? And all of a sudden they put into that property $50,000 of upgrades and construction on it to make it more attractive to buyers, and they turn around and they flip it for $100,000. So they make $50,000 on the project or whatever it is, and they flip a couple houses a year. You know what I mean? Doing that other side business. That should be its own distinct, separate entity, 100%. That is a new business that is used for a separate purpose. It should not be tied into your long-term hold businesses. It's also going to provide you a lot more risk, because you're doing everyday work on it, and you're doing construction and labor on it, which is exposes you to more risk and different risk than, say, a long-term tenant. And it should be treated from a taxation standpoint as a different entity too, probably.
Let's talk about that for a second, because that's often an overlooked point, right? And is, what exactly are you engaged in these businesses doing, and how are you approaching them, right? Because you may have, or at least what I see with a lot of our clients is, they have their passive income, right? And setting aside securities and 401ks and brokerage accounts, they, like you were saying, we deal with a lot of guys involved in real estate, so they'll own various properties, and those are passive income. So there could be liability that arises from within those properties, but you normally just have tenants in there, and if you're managing it right and you've discussed, avoid the commingling, then you can limit that liability. You can get insurance for a lot of that liability, and you have a certain level of protection. Then you have other businesses where you're coming in as just purely as an investor, right? And you're not involved in the day-to-day, right? You're not hiring the trades. You're not the one that left the construction site and forgot to put up a sign or the caution tape, or left the pool with the rebar sticking out, right? You're not actually doing the stuff. You're just a passive investor. You put in money, and you're just a limited partner, depending on the structure that exists. But then what you were just describing here is a lot of, at least particularly our clients that are involved in the construction space or in property management, buying and flipping, they are boots on the ground, right? They're showing up to construction sites. They're sometimes operating. When somebody calls out sick, they'll jump back on that Bobcat or whatever it is and dig a trench and figure it out. And they'll leave a hole on a property or a pipe or whatever. So it's that direct liability that, they're just, while they're working, something could go wrong. So I think what you're saying is, it's important to understand what your exposure is in a particular investment or endeavor, and then structure it correctly and keep it separate.
100%. Separate bank accounts.
Yeah.
Separate, you don't want to use the same business card when you go to Home Depot, things like that. You want to make sure that this is its own entity and its own business, even though it's a real estate related business. It is its own distinct business. It shouldn't be treated, your duplex where you have two tenants in, and it is essentially passive income where they pay you monthly. You're going to have things that need to be done on that occasionally. A pipe bursts, electrical circuit fails. You hire an electrician, they go out there. You hire a plumber, they go out there, they fix it. That should be all its own stuff and segregated away from any of your other businesses. Likewise, if you are a GC, a contractor, who installs hurricane windows, that's big business here in Miami, right? You got a good thriving business and you're putting in hurricane windows. That's its own business. should be treated as its own business. Purchases that are made through that business should run through that business exclusively. It shouldn't have any other commingling with this other business.
Right.
And then because you are a general contractor and you have the know-how, and you also see and identify some properties that are attractive to you, that you think you can beautify a little bit and fix up and turn around and flip them for a profit, that's its own business as well. And like you said, you're going to be doing a lot of work on that, and there's going to be a lot of boots on the ground, so to speak, and a lot of machinery and a lot of equipment and more exposure to risk. That needs to be its own entity, that needs to be its own, treated as its own business, needs to have its own accounts.
Yeah, there's two primary, I don't know if they're issues, or there's two primary things that I feel like hold people back from pursuing this. One is lack of knowledge and information, right? Like not fully understanding about commingling, right? You know, I'll have clients that they have a successful business, they purchased a property, but just for convenience, they start collecting rents on that property into their primary business. And so we obviously want to prevent that. And so it's important to have that distinction between the entities and making sure that they're separate, and that's going to drive at your exposure and liability.
That's an important part, thing to mention, since we're discussing that. None of this works, this whole isolating and segregating liability via different business entities, whether it's a corporation or an LLC, if you're doing this stuff and you're commingling accounts. Then if you are using the same card to buy Home Depot supplies for all three, right? Or you're depositing monies from your rental income into the same account as your flip business and stuff, and you're starting to mix these accounts and treat them as all one big business, then there's a principle under the law called piercing the corporate veil, which can occur, and which then all of a sudden makes all of these entities, which you went through the trouble of creating, useless, essentially. And they all can be liable for the same thing, because what is the court going to do? And what is the attorney who's going against you going to say? No, look at this guy. He's putting all his monies in the same place. He's using them all for the same stuff. These aren't really independent businesses. Right. This is all one entity run by Sean or Dick or whomever. And they should be treated as one entity, and we should be able to recuperate from all these entities. And once you go down that road and you keep things sloppy and you don't keep them isolated, then all of this structure that you've worked hard to understand and implement becomes meaningless.
Yeah, and that's the
administrative burden is equally important.
That's the administrative burden, and I understand. You know, for clients that have the typical client we were describing earlier that's been, you know, working hard for 20, 30, 40 years, and whether by luck or through, you know, them being hard work and profession, they've been able to avoid liability in a big lawsuit, and they've made it this far, and
been successful in doing so.
And once they create this structure, there is some initial legal cost to create it. I don't. When you look at our clients that have, sometimes they don't even realize it, right? Because they've acquired 5, 10 properties, and given the appreciation in South Florida in the last 10 years, now their net worth is several $1 million. So when you look at what the legal costs to protect these things are, it's almost de minimis. It's not insignificant. But depending on the complexity, there is a cost to get the lawyers to do it right.
If you own 10 properties and you don't have them each in their own independent LLC and business structure, you're creating a huge problem. And if you're not running them as independent businesses, you're creating a huge problem. Think about it, like we just said, you know what I mean? In Miami, any piece of property is going to cost you $500K minimum, you know what I mean? If you have 10 properties and 10 renters, how much money in rental income are you acquiring per year? You know what I mean? $1,500 a month, $15,000 a year times 10. You have a significant asset. Treat it as if it was a significant asset. Treat it like it should be treated, so that way you don't lose it all in the unlikely event that a real disaster strikes.
And the second issue, which is that sometimes I find that to be the even bigger hurdle for clients, is not the initial setup cost, is that they have the greater administrative burden, right? And sometimes that may mean hiring more people.
Get a bookkeeper, get an accountant, do what you need to do to operate your books the way that they should be operated, as if each of these homes or duplexes or whatever
Businesses, yeah.
are their own businesses, because they are. And if you treat them that way, it might be a little bit of a pain in the neck at first to set it up and get it all together, but once you got your QuickBooks or whatever set up and you've got your bookkeeper handling it and it's in place, you're going to have a lot more peace of mind, and you're going to prevent that real disaster from striking. That's what the law is designed to do. That's how it should be set up.
Yeah. Okay. Hey, well, Sean, thanks very much for coming today. Appreciate your time. I think this will be very valuable for our clients and anybody who watches. Appreciate your time, man.
Cool. Happy to be here.